In 2016, police in Huron County received an anonymous call about a suspected drunk driver. An officer pulled the woman over, and police say she was driving under the influence with an open container of alcohol in the vehicle with children in the car. But the Michigan Supreme Court recently ruled that the stop violated the defendant's constitutional rights and said evidence obtained in that traffic stop could not be used against her. I asked local attorney Bryan Waldman to help make sense of this opinion for this week's Legal Edge.
Well, it's not a question of whether the evidence was there, it's how the police obtained the evidence. And the reason for that is the government has an interest in balancing its obligation to enforce the rules with protecting individual rights. And here the individual right is against to be free from an unreasonable search and seizure, which is protected under both the U.S. Constitution and the Michigan Constitution.
So what are the facts in this case that convinced the court to find that the stop was unconstitutional?
For the stop to be constitutional, the police have to have reasonable suspicion to detain someone. They're essentially seizing the people who are occupants of the vehicle when they stop, even if it's to investigate. And so to determine if there's reasonable suspicion, you have to look at the facts of every case, like you said. And in this case, what they looked at was the caller was anonymous that called to tell the police they suspected this person was drunk driving. And they felt they were drunk because they saw them yelling at their kids and being obnoxious. And the court said, that's not enough.
So does this mean that the officer then would have had to observe themselves, the person swerving? Or does this mean that an anonymous call, you just have to go by more than just an anonymous call?
Well, good points. So the officer did watch the car for a while and saw no suspicious activity. So pulled the driver over strictly based on this anonymous tip. If the police officer had seen the driver swerving or doing something to indicate that she was driving drunk, obviously that would be reasonable suspicion. And then the court said the tip itself has to be, whether it's anonymous is a factor. But the important thing here was yelling at your kids and being obnoxious is not indicative of drunk driving necessarily. We all know people who are obnoxious. We all know people who yell at their kids. It doesn't mean they're drunk drivers. But if the report was that the person was swerving or driving on the wrong side of the road or not able to stay in her lane, then that might have been enough to give reasonable suspicion. No one should be discouraged by this opinion. You still should call in if you think there's a dangerous situation going on. It's better to leave your name if you have to be anonymous, do it, but know that you're helping the police more if you're not anonymous. And then the more information you can give that specifically relates to the type of criminal activity you're reporting, the better it's going to be for the police in terms of trying to demonstrate that reasonable suspicion when they make this traffic stop.